Today, I want to answer three of the most frequently asked questions I hear as a family law attorney. I'm David Steerman. For over 3 decades, I've been helping families deal with their divorce, custody, support, cohabitation, prenuptial, and postnuptial agreement issues here in Pennsylvania. Some of the most frequently asked questions that I hear as a family law attorney on a weekly basis include the following. Do I need a lawyer if my spouse and I are working with a mediator? The answer to that question is an easy one. Absolutely. In order to be properly informed while going through mediation, it's important for you to have independent legal counsel to advise you of your rights and responsibilities in connection with the issues that you're going to be dealing with. Even though you're working with a mediator, that person is paid to assist and help facilitate agreements. If you don't know the laws or you don't understand your rights or obligations, it's hard to come to a fair resolution. In some cases, parties even have their counsel participate in the mediation process. There's nothing like having another human across the table from you, explaining the laws, answering your questions, and helping you understand better your rights and responsibilities. It's important to remember that the mediator is there to help facilitate agreements. It's not their job to educate you or your spouse about the law. The next frequently asked question I hear is, will I get more of my assets and less obligation for liabilities if my spouse cheated on me, abused me, or treated me poorly throughout the course of my marriage? In Pennsylvania, the answer is no. Pennsylvania's equitable distribution statute specifically says that marital misconduct during the marriage is not a factor the court consider in determining equitable distribution or the division of the assets and liabilities. In fact, the statute specifically provides that at the outset. Rather, they have 11 different factors that the court can consider and is required to consider in deciding how to divide assets and liabilities acquired during the marriage. Take a look at some of my other videos to learn more about the 11 equitable distribution factors and how courts generally work with them. I also often hear this question or assumption, and that is that I've been the primary caregiver and caretaker of our children throughout the course of our marriage. I'll get full physical and legal custody, won't I? The answer to that question is often no. Just because your spouse may have been a full-time income earner and focused on his career or her career and not involved in the day-to-day care of your child or children, the reality is when you separate or divorce, courts give both parents an equal opportunity to help raise their children. At the same time, the court will often tell that individual they're expected to have an earning capacity. In Pennsylvania, more and more courts are awarding equal shared physical custody as long as both parents are capable, competent, caring individuals without any significant form of impediment like drug addiction, alcoholism, physical abuse, sexual abuse, or emotional abuse. In determining whether parents have 50-50 custody or any other form of physical custody, the courts in Pennsylvania consider 16 factors in determining the best interest of the child or children at issue. If you have questions or concerns and want to learn more about the 16 factors the courts consider in Pennsylvania, check out my earlier videos on that topic. These are just three of some of the most frequently asked questions I hear on a weekly basis as a family law attorney in Pennsylvania. I hope that my responses will help you make calmer, more strategic, and thoughtful decisions in a time that can feel exceptionally chaotic. If you have additional questions on any or all of these topics, feel free to reach out.